Hi, I'm Jacob Hornberger, president of the Future of Freedom Foundation, and this is this week's Libertarian Angle. The show that y'all know brings you the principled, uncompromising case for the libertarian philosophy. I'm not joined by my co-host, Richard Ebeling. As y'all can see, he teaches economics at the Citadel, and he's buried under school commitments. So this week, you get a solo. And if you're new to FFF, come to our website at fff.org for 32 years of principled arguments on libertarianism. Also subscribe to our FFF Daily, which we have strived for more than 20 years now to make the best libertarian commentary page on the internet on a daily basis. We publish a monthly journal called Future of Freedom, which is by subscription, which we'd invite you to subscribe to. We'd also invite you to donate to FFF if you like our work. And we've got tons of conferences and videos. We're running right now a great conference online called End Inflation and the Fed. We've had 3 great lectures. We've got a 4th one coming up Monday night. We do it by Zoom. We'd invite you to attend. So I want to talk to you about a legal case. That case involves the famous commentary conspiracy theorist Alex Jones. As many of you know, Jones has been hit with 2 large jury verdicts that have created lots of controversy, especially among his supporters. And this week I wrote an article entitled, "Alex Jones Got What He Deserved." And I explained why that was the case. And I got a couple of emails criticizing my position and explaining why they were criticizing my position. So I want to address those critiques in this particular half hour here at the Libertarian Angle, and to put things kind of in a wider context here. But first, let me give you some background. So there was a big gun massacre in Connecticut where lots of children were killed, and the parents of these children ended up suing Alex Jones. Now, why'd they do that? Well, Jones, after this massacre at Sandy Hook, Connecticut, he published statements and repeatedly published statements that these parents, these families, were just making up the story, and that they were doing this as some sort of gun control agenda. They were hoping to get gun control adopted, and so they were making up this story about their children being killed. I mean, it was classic conspiracy theory, but it was false. In fact, these people's children really were killed. And so in addition to the suffering that they were experiencing as a result of losing a child, as you can imagine, they were now having heaped on them, a lot of threats and calumny, adverse comments from Jones's loyal right-wing supporters. They were, contacting them and issuing threats and bad comments, because they believed what Jones was saying, that this was just a conspiracy that these parents had entered into. So it got so bad that some of the families had to move out of their house and try to move into another house and then another house. Some of them moved like 5 or 6 times because of the large amount of threats and calumny that they were experiencing from Jones's supporters. So they ended up filing suit against Jones, primarily in Connecticut. Several families there filed suit that were all involved in this one case, but one of the families was in Texas, and they filed suit in Texas. Now, the Texas trial went first, and the jury came back in with an award of around $4 million in compensatory damages. Now, what does that mean? Compensatory damages are designed simply to make the plaintiffs whole, to compensate them for the damages they've suffered as a result of the wrongful action of the plaintiff. They're not designed to punish the plaintiff. They're designed just to compensate the plaintiff for the damages that the plaintiff has suffered. Now, the jury also awarded around $49 million in punitive damages against Jones. Now, punitive damages are designed to punish the defendant. They're designed to say, you shouldn't have done this, that your action was intentional, and you did it with knowledge of the falsity, or you did it with malice, and we're going to punish you for it. And a lot of times, a factor in this is how much the defendant's worth. Because obviously, if a defendant's worth, $1 billion, imposing a punitive award of $2,000 isn't going to mean very much. And so in such cases, the jury oftentimes takes into account how much the defendant's worth. So in this case, they awarded $49 million in punitive damages. Now, it's not clear that that's going to be upheld under Texas law. Texas law has a limit on the amount of punitive damages, and so time will tell whether the courts uphold that portion of the verdict. As far as the $4.1 million, Jones felt that was a victory. I mean, that 4.1 is not a lot of money insofar as he's concerned. Different story in Connecticut. The jury in Connecticut just came out with an award of some $965 million in compensatory damages. Now, keep in mind that this is spread out over several families. The largest award to any particular family was let me fix my microphone here. The largest award was $120 million to one particular family, and then the rest of it is spread out. Still to be decided is the issue of punitive damages, but in Connecticut, like in Texas, punitive damages are limited. In fact, in libel and slander cases, they're limited to the recovery of attorney's fees. But what's interesting is that the Connecticut families also sued under a long-established tort under the common law and under the laws of many states called the intentional infliction of emotional distress. Now, this involves a tort, or what the law refers to as a legal wrong, a tort, that might not be defamatory, but just designed to intentionally inflict emotional harm on somebody. They also sued under what's called the Connecticut Unfair Trade Practices Act. I'm not really sure how they put that together with what was going on here, but I think it involves Jones's use of this conspiracy theory to sell things. But in any event, that law permits the recovery of punitive damages. So that part of the case still needs to be decided. But what Jones and his supporters are upset about, obviously, is the $965 million compensatory award that was given to these families by the jury. So I wrote an article saying, well, look, this is entirely justified. I mean, this is horrendous what he did. I mean, these people had already lost children, and then to suggest that they were lying about it, that's just classic libel and slander. You don't issue defamatory statements of this nature, and then the fact that he told it to his supporters who believed it. I mean, let's face it, Jones's supporters believe just about anything he'll say. I mean, it's just this loyalty to Alex Jones, and so they believed what he said, and they came down hard on these people, which means that that's damages that flow from the original defamatory comment. So as far as I was concerned, Jones got what he deserved. Okay, so I got a couple of emails, though, that said, wait a minute, Jacob. The first email says that, this is a terrible fine that he's received, this $965 million, that this is unconstitutional, that he's been fined this much money, and that the Eighth Amendment clearly prohibits the imposition of this kind of fine, and this is really out of bounds. Well, there's one big problem with that suggestion, and that is that Jones hasn't been fined. Fines are in criminal cases, not in civil cases. Fines are what the judge imposes on a criminal defendant who's been convicted of some criminal offense. And the Eighth Amendment refers to criminal cases. In civil cases, we're dealing with damages and not fines. And the compensatory damages, as I've already said, deal with the compensating the family, making them whole for what the damage that's been caused by the defamatory statement or some other tort. It's like in an automobile accident. You get in an automobile accident, and the plaintiff will sue for damages. Well, those damages consist of medical expenses, or if he's lost an arm, the law will figure out some compensation for that loss of that arm to make the person whole. Not by giving him a new arm, of course, but by coming up with a monetary figure that will, compensate him for the loss of an arm. Obviously, no amount of money would do that. Nobody would ever trade it. But the law does recognize monetary awards with respect to making the plaintiff whole. And so that's what's happened in both of these cases. We're talking about compensatory damages. Now, the punitive damages side of this thing is not a fine that the state's imposing, like in a criminal case. This is simply what the jury is determining is necessary to punish the defendant for what he's done. So you got two separate sort of awards here: the compensatory damages awards and the punitive damages awards. Now, in these critical emails I received, I also got a point that said that Jones was complaining that the judge had not permitted him to submit evidence, relevant evidence. And primary among these arguments that Jones was making was that his free speech rights entitled him to make these statements, that he's got the right to go on the internet and say whatever he wants under principles of free speech. Well, the problem is the law doesn't recognize that. The law has been well settled that free speech does not encompass false and defamatory statements. That you just don't have the right to do that under principles of free speech, to destroy a person's reputation or to make up false and defamatory statements about him. Free speech doesn't encompass this. And everybody knows this, that there are libel and slander laws. And I have no doubts that Alex Jones knows that there's libel and slander laws in the context of principles of free speech, that there's a limit on principles of free speech in that regard. Now, but let's assume that Jones didn't know that. Let's assume that he just innocently thought that there were no libel and slander laws. Well, that still doesn't provide him any kind of defense. That he's ignorance of the law is no excuse. That's an old adage. Ignorance of the law is no excuse. I think most of us have heard that. And the fact that he didn't know that might not have known that there were libel and slander laws in existence, well, that doesn't provide him a defense, because that's the law, and he is charged with knowing what the law is, especially when the law is pretty famous and has been so long established. Libel and slander laws are nothing new. So there's a reason why the judge would not permit Jones to come up and say, well, I got free speech rights. The judge would hold this is immaterial, because the law is well established that your free speech rights do not give you the right to go out there and issue defamatory statements. So the liability part of the case involves whether Jones made the statements, and if so, were they defamatory? And then you've got the damage portion of the trial where the jury will assess damages. But first they have to find the liability. Did he say what he's alleged to have said, and was it defamatory? And so the judge holds, well, your free speech rights are irrelevant in that part of the case, but also in the damage part of the case. Now, there was an interesting twist, though, in this particular case, because the judge issued what's called a default judgment against Jones. Now, a default judgment is one of the most extreme remedies in civil law. It will very rarely be imposed, because the appellate courts will look for any excuse to reverse the trial judge's imposition of that particular penalty, because it's so extreme. Now, what is a default judgment? Well, a default judgment is when somebody sues and the defendant doesn't even answer the suit. He gets served with the suit, but he says, I'm not going to answer it. Many times this happens because the defendant knows he owes the money. Let's say a bank sues on a promissory note, and the defendant knows he signed the promissory note. He knows he's defaulted, and he doesn't want to go hire a lawyer because he's got no defense, and so he doesn't even answer the suit. So the plaintiff's lawyer goes into court and asks the court for a default judgment. He wins by default, and the judge will then issue that judgment against the defendant because the defendant has chosen not to answer. But here, the defendant answered. Jones had a lawyer representing him, or maybe even more than one lawyer representing him. So how is it that the judge can issue a default judgment against Jones when he's answered the lawsuit? Well, in a civil suit, you have what's called pretrial discovery. This is under the rules of civil procedure in every state, and under the federal rules of civil procedure for federal cases. Now, this was a civil suit there in Connecticut. And under the rules of civil procedure, both sides have the right to take the deposition of the opposing side and to engage in what's called pretrial discovery, get relevant documents and records and so forth. Well, for Jones's deposition, he didn't show up when at the appointed time that he was supposed to show up. I assume that he later showed up. I'm not really sure of that. But what happened was that he did not produce documents and records that he's required to produce when the plaintiff asked for them. And then what happens is the judge doesn't just issue a default judgment right away when the plaintiff's attorney comes and says to the judge, look, he's not complying. That's not the way it works. I mean, there's no way that kind of default judgment would ever be upheld on appeal. Instead, the judge will issue an order, and he will order the defendant to produce these records. Well, even after issuing the order, Jones didn't comply. And so the judge, if the judge is faced with a party that's simply not going to obey his or her orders, then he or she is going to issue sanctions. And a possible sanction is contempt, and cites the party with contempt, and maybe even orders his incarceration until he complies with the order. But in this case, the judge simply issued a default judgment and said, look, if you're not going to comply with my orders, then you lose on the liability side of this case. And that's precisely what happened. So Jones has no one to blame but himself, because all he had to do was to produce these documents and records, and the default judgment would not have been issued. So that's another reason why his free speech evidence would have been disallowed, because he was not permitted to participate in the liability portion of this case because there was no liability portion. There was a default judgment. The case essentially operated on the basis that Jones hadn't even answered the suit, just like a regular default judgment. The judges declared they win automatically on the liability side. So the only thing that was left was the issue of damages, and Jones participated in that. And he and his supporters are, terribly upset. They're calling it a kangaroo court, which I'll address in a minute. That this is a terrible thing. But the fact is that, and they, in this email critique that I got, the person said that Jones had admitted that he had done wrong. Well, that may well be true, but it's totally irrelevant with respect to compensatory damages. Because again, the idea of compensatory damages is not to punish. It's to make the plaintiff whole. And the jury sits there and hears all the evidence, and they weigh the evidence, and they deliberate, and they decide what is the proper amount to award to make this plaintiff whole. And one might think, well, $120 million is a large amount of money. It certainly is. But we're not there hearing the evidence. The jury is in that courtroom hearing the evidence as to why this is a just award based on the damages that these people suffered as a result of what Jones had done. Now, if Jones expressed apologies and remorse for what he did, that would be a way to mitigate punitive damages. But in this case, it's entirely possible that the jury didn't put much credence in his remorse anyway. He at the trial in the damage portion of the trial in Connecticut, Jones told the jury that he was done apologizing for Sandy Hook. Well, that's not the type of thing that goes over well with juries. They want to see genuine remorse when somebody does something wrong. But in any event, like I say, the punitive damages there is still left hanging. Now let me address this kangaroo court business, because I see a lot of right-wingers are saying that this was a kangaroo court. This was a kangaroo court. And well, they're obviously referring to both the Connecticut case and the Texas case. Now, what do they mean when they say this was a kangaroo court? What they're saying is that this is a court where the verdict is preordained. That these courts were just out to get Alex Jones because he's a conspiracy theorist and he's a right winger, and that Jones never had a chance to win. Now let me give you an example of a real kangaroo court, and I point this out in the second article that I published this week. Alex Jones Got What He Deserved, Part 2. A kangaroo court is what the Pentagon and the CIA have at Guantanamo Bay, Cuba. That's their judicial system at Guantanamo Bay. They don't have jury trials. They don't permit jury trials. They don't like jury trials. They hate jury trials. Their trials there are by military tribunal. And military tribunals are characteristic of totalitarian regimes, communist regimes. You'd find tribunals in Cuba, the other side of Cuba, under the communist regime there. You're not going to find a jury trial there. You're not going to find a jury trial in China or Russia. These are judges or tribunals deciding guilt or innocence in criminal cases or factual disputes in civil cases. Well, the system in Guantanamo Bay is a kangaroo court. I mean, the verdict is preordained. If people ever get a trial there, and they don't ever give them a trial, they promise them a trial there, the military does. They've been promising a trial for 20 years. Can you imagine that? I mean, the Constitution requires a speedy trial, but it doesn't. The courts have held that doesn't apply to the military, the Pentagon, and the CIA. They're immune from the Constitution in that regard. So they've held people there for 20 years and so forth. But if there ever is a trial, the verdict's preordained. There is no way that a military tribunal consisting of military officers is going to find an accused terrorist not guilty if the superior officers of those officers on the military tribunal, or the president, who's their supreme commander-in-chief, doesn't want it. If whatever the president wants and whatever their superior officers in the Pentagon, the chain of command want, that's what that military tribunal is going to do. That's what's called a kangaroo court, because it's like a show trial. It has the appearance of a trial taking place, but we all know what the verdict's going to be. We all know what the outcome's going to be. That's a kangaroo court. Now, that's another reason I bring that up is because the right-wingers that are complaining about the Alex Jones verdicts, they never complain about what happens there at Guantanamo Bay. I mean, take a look at their articles. Take a look at their podcasts. Take a look at their speeches, their lectures. You will rarely, if ever, see them condemning the operations, the judicial operations, and I put judicial in quotation marks, there at Guantanamo Bay. You'll search in vain for any articles that are saying these things need to be terminated. Look back at the articles of right-wingers for the last 20 years. Oftentimes they come out in support of these kangaroo tribunals. And why is that? Because right-wingers hold the Pentagon and the CIA in the highest esteem. I mean, for them, these are their God. They're not about to criticize what the Pentagon and the CIA does to these suspected terrorists. Whatever they want to do to these suspected terrorists there at Guantanamo Bay is fair game as far as a right-winger is concerned. So that's normally how you can tell that they're right-wingers. You're not going to find any articles or speeches or podcasts or anything calling for the termination of this kangaroo court system in Guantanamo. In fact, here's another telltale sign of a right-winger. You will never see them, or rarely see them, calling for a dismantling of the Pentagon, the CIA, the NSA, the national security state under which we've lived since World War II, as we have been calling for here at FFF and the restoration of a limited government republic. Right-wingers don't want a limited government republic. They hate that concept. They love big, huge, standing military establishments. They love the Pentagon. They love the CIA. They love the NSA. They love the surveillance state. Oh, they'll call for reform. The system needs reform, surveillance reform. After Edward Snowden revealed all the illegal surveillance that was being taken place of the American people by the NSA, or Pentagon reform after Julian Assange revealed all the dark side secrets, or some of the dark side secrets of the Pentagon and the CIA. I mean, or when it came out that the CIA was involved in torture, and they went in and destroyed their torture videotapes that they had maintained. The right-wingers will say, well, okay, the system needs reform, But you'll know that they're a right-winger by the fact that they will never call for the dismantling of the CIA, or rarely, maybe, once in a blue moon, once in 20 years or so. And as we've long pointed out here at FFF, if you want a free society, then you need a limited government republic. Because there's no way that people who are living under the omnipotent state, the national security state with the powers of assassination, indefinite detention, trial by military tribunal, and so forth at Guantanamo Bay, secret surveillance, state-sponsored assassinations can never be considered free. So that's a kangaroo court, and right-wingers love it. But they come around over here to the jury system in Texas and Connecticut and say, oh, this is a kangaroo court. This is ridiculous. How can it be a kangaroo court? That these are jury cases. Now the jury system, which right-wingers hate, they just hate the jury system. They'd rather have a judge up there deciding civil cases and judges deciding criminal cases. The jury system is one of the greatest things that our ancestors bequeathed to us, both in civil cases and criminal cases. In criminal cases, they have the right of nullification. They can find defendants not guilty, even if the state has proved their guilt. I mean, that's a judge would never do that, or a tribunal would never do that. But this notion that these verdicts were preordained, like in a kangaroo court, is ridiculous. My experience with jury cases, some of you know I practiced law for many years, is that juries juries are composed of just regular people that are brought out in the community, and they're deciding the guilt or innocence of a person in a criminal case, or they're deciding a civil dispute. And my experience is that juries have a much better sense of justice than any judge ever will and any tribunal ever will. They may not understand all the complexities of highly technical cases and so forth, but in terms of just the sense of justice, juries are fantastic. I'm not saying that the jury system is perfect. We know that human beings are not perfect, but it's the best system that exists in all over the world and in history. The jury system, trial by jury in both civil and criminal cases, and in the federal case, the federal constitution, in federal cases, jury verdicts and jury trials in civil cases are guaranteed, just like they are in criminal cases, at least in civil cases involving a certain amount of money. So the thought that these verdicts are preordained like in a kangaroo court is ridiculous. These 12 jurors got together in a conspiracy to put it to Alex Jones and his right-wing supporters, and they're all their conspiracy theories? Ludicrous. And notice this, you've got two different verdicts in different parts of the cases, one in Connecticut, one in Texas, that have issued verdicts against Alex Jones. What? The right-wingers are saying that these two juries, 24 people in different states from different parts of the country, got together in a massive conspiracy to put it to Alex Jones and his right-wing supporters so that they wouldn't have free speech rights. It's ludicrous. These juries went in there, they listened to the evidence, they weighed the evidence, and they came out with verdicts that are well justified based on what Alex Jones did. Now, let me wrap this up by bringing up something else about right-wingers. They always love, one of their favorite mantras is, Jacob, with freedom comes responsibility, right? Haven't you often heard right-wingers say that in their speeches and on their websites? With freedom comes responsibility. And they often chide liberals for not taking responsibility for their actions or for their beliefs. You see, that's part of what all this immigration, transportation nonsense that right-wingers are engaged in. Liberals need to take responsibility for what they're saying about their sympathy for immigrants and so forth, right? I mean, isn't that the concept here? Well, what about right-wingers taking responsibility? Why shouldn't the right wing be required to take personal responsibility for their actions? Why should they be held immune? Because they're a right-winger? Because they're a conspiracy theorist? Where in the system of justice does it say that right-wingers and conspiracy theorists like Alex Jones should be given immunity for personal responsibility? Jones did something wrong. Even by his own admission, he did something wrong. Why should he be held immune from the concept of personal responsibility simply because he's a conspiracy theorist or simply because he's a right-winger? Right-wingers don't want to hold liberals immune from the consequences of their action. You see this in welfare state programs, right? Right-wingers will say, well, you need to be held responsible for the natural consequences, the adverse consequences of your welfare state programs, all the adverse consequences that have brought them about. Don't we often hear that? And of course, the liberal will say, oh, no, I don't want to be judged by the actual consequences of my actions or my programs or my beliefs. I want to be judged by my good intentions. Well, isn't that what's happening here? Aren't the right-wingers saying, oh, let's just judge Alex Jones by his good intentions, not by the actual consequences of his actions? Let's give him immunity from personal responsibility. Let's just hold the liberals responsible for their actions. I say no. I say that we need to hold everybody responsible for their actions. And that's what civil cases are all about. That's why we have a government that involves a judicial forum where people can resolve their disputes. Now, finally, let me address, there are some libertarians who claim that libel and slander laws are illegitimate. Okay? They don't believe in libel and slander laws, and therefore they say Alex Jones shouldn't be held responsible because libel and slander laws are illegitimate. Well, one problem with that is that's just not the law. I mean, it's been the law for centuries that libel and slander is recognized as actionable. Take, for example, a case where the president of a corporation in a small town wants to bring harm to a little guy who's a janitor in the town, and he says that he saw that guy molest a child. And so everybody believes the president of the corporation, and the janitor gets fired. He can't get another job, and the libertarians that hold that libel and slander laws are illegitimate would say, well, yeah, tough luck for the janitor, but that president of that corporation has a right to do that under principles of free speech. There should be no libel or slander with respect to that particular case. I couldn't disagree more. I believe that the libertarian philosophy encompasses more than just actions that involve the initiation of force. One of them is fraud. Some libertarians say, oh, no, fraud is not actionable, Jacob, because it doesn't involve the initiation of force. So people, they go out and defraud others. Oh, no, can't sue for fraud, Jacob. Doesn't involve the initiation of force. I say that's nonsense. And I say it's nonsense with respect to libel and slander laws. I believe that janitor has every right in the world to file suit for slander and libel for what that president of that corporation has done intentionally to bring harm on that janitor. And I think punitive damages are entirely appropriate to teach that corporate president a lesson not to do this again. There's also libertarians that don't believe that unethical conduct should be actionable. I mean, let's say a lawyer that takes money under the table from the other side in order to compromise the interests of his client. There's no initiation of force there. But again, I would say that libertarianism cannot countenance that type of thing with respect to our philosophy. Most actions involve the initiation of force that libertarians condemn. But when it comes to fraud or defamation or unethical conduct, it is my conviction that libertarianism certainly does not condone or approve of such actions, or argues that such actions should not be actionable in a court of law. That's why we have courts of law, not only in criminal cases to punish the malefactor there, but to provide a means by which people can peacefully resolve their disputes. All right, that's my commentary for this week. That's this week's Libertarian Angle. Look forward to seeing you all next week again with Richard Ebeling. Again, if you're new to FFF, come to our website at fff.org for 32 years of principled and compromising articles, conferences, podcasts, and so forth.